Good morning. This is Kaya Bromley, President and founder of your Obamacare Advisors, and you are here attending our webinar series, The Countdown to Obamacare. And this week we're talking about the 90-day rules and the 5 things employers need to know to avoid costly mistakes. Today is October 22nd. So as I said, I am the founder and president of your Obamacare Advisors, and I've written a book called The Employer's Guide to Obamacare, and that book is available on Amazon. And I've been advising business owners in the restaurant and farm labor and service industries for several years now on Obamacare. And we've put together this presentation to help drill down into the details that employers really need to be thinking about as they get ready for January 1st. And this week we have joining us Ryan Mulder. Hi, Ryan.
Hi, how are you doing this morning, Kaya?
Great, great. Thanks for joining us again. So Ryan is a partner at Healthcare Attorneys, and he's one of the most informed attorneys on the ACA that I have met. He's written extensively on the ACA in general, but also specifically about the 90-day rules. So we're going to have, you're very lucky to have some great insight from Ryan on this topic. We're going to keep it really short and brief and to the point, so we want to get you guys back to work as quickly as you can. So first I want to say thank you to our sponsor, FreedomCare Benefits. FreedomCare Benefits is a completely ACA compliant solution for business owners, and they are sponsoring this webinar series. So as with every webinar, first I have to give our warnings that this is not a substitute for legal advice. We are giving you our legal opinions, but you need to really make sure that you are looking at this in your own context with your own lawyers and your own CPAs, your own legal department to make sure that you're in compliance with the law. And I want to also stress there's a lot of people that are still not worrying enough about the ACA. We don't want you to panic, but you're really running out of time if you haven't already picked your strategy and your solution. You really need to do that, and especially we're advising that you get that in place before November 15th, before open enrollment begins. So with that, there is some good news about the 90-day rule, and that's that you're not as dumb as you thought you were. It is confusing. It seems like it's a really simple rule, but if it were that simple, then Ryan wouldn't have been able to write one of the most technical articles you've ever written, right, Ryan?
That's exactly right. This is yet another area of the ACA where certain provisions of it don't fit too well with other provisions of the Affordable Care Act.
And not only that, in order to even understand it, you have to understand other areas of the law, right?
Correct, right. You could be in compliance with the 90-day waiting period and not in compliance with Section 4980H, the penalties aspect of the Affordable Care Act for employers.
Yeah, so make sure that you guys heard that. That's one of the most important things you're going to hear today. You could be compliant with the 90-day rule and still be in violation of Penalty A and Penalty B. That's a major thing that you need to understand, and we're going to get into that in the next couple of slides. So before we get into our 5 steps, we're going to first look at the definition. And I have a little pitchfork there to show that the devil's in the details. It seems really simple, but it's not. So beginning in 2014, a group health plan or health insurance issuer offering group health insurance coverage may not apply any waiting period that exceeds 90 days. So that seems like there's just a 90-day waiting period. Why is it so confusing? Well, we are going to get into that, but first I want to talk really quick about the penalties for screwing it up. First, there is the $100 per employee per day. That's the actual penalty if you do violate the 90-day rule. But it also a violation can also trigger, or I would say applying it improperly can also trigger penalties A and penalty B. It's not a direct penalty, but it can easily be triggered, and we'll talk about how that can be and how to avoid it. So first, we're going to go into, we've narrowed it down into 5 things that you need to know to avoid the costly mistakes so that it's easy for you to understand, so that you're going to walk away from this webinar with actual usable knowledge of the things that you need to do and know regarding the 90-day rule. So first, we're going to talk about understanding what is a waiting period. So Ryan, I'm gonna turn this one over to you. Can you talk a little bit about the definition of a waiting period, and also specifically that nasty little language of who is otherwise eligible?
Right. So, I mean, I'll just read the slide. The period of time that must pass before coverage for an employee or dependent who is otherwise eligible to enroll under the terms of a group health plan can become effective. So a waiting period is essentially the passage of time, and it cannot exceed 90 days under the Affordable Care Act. And one thing I think it is important to point out is the 90-day waiting period applies to all group health plans, even if you're not an applicable large employer. So you may have to comply with the 90-day waiting period before you have to comply with 4980H, which is something to keep in mind if you are a smaller employer listening to this webinar. So if you're offering group health coverage, there cannot be a waiting period that exceeds 90 days, unless one of the exceptions applies.
Yep. And the next slide I have here is talking about the otherwise eligible to enroll. Do you want to talk a little bit through this one?
Sure. So basically the regulations set out what counts as being otherwise eligible to enroll, and those things include things such as a job classification, such as a job title, or meeting a license requirement, for example, passing a CPA exam or some other professional job requirement. And then also finally there's the orientation period, which can be used by employers as long as it's a bona fide orientation period.
Yep, and we'll talk about the orientation period next. So in other words, it seems very confusing, this language that they always have to torture us with, otherwise eligible to enroll. But it's basically if the employee is eligible and the only thing left to happen was the passage of time. They always use confusing words, but it's basically that they're eligible. And this is an area too where we get into, I know I've talked a lot in my previous webinars about getting plan documents done, making sure that you have the appropriate job classifications and these types of things spelled out in your plan document, your employee handbooks, things like that, is really critical, because if this ever becomes an issue, the argument over otherwise eligible to enroll, you want to make sure that you have that well documented. So we'll go to number 2, which is understanding the orientation period rule. And of course, with everything ACA, they have ACA math that isn't like any other math that anyone would usually think of. So under the ACA, the orientation period for an employer can be 1 month, which actually means 1 month minus 1 day. And we'll show an example of that in a minute, but Ryan touched for a second earlier about being bona fide. The key here is that it can't just be a strategy that an employer has implemented to try to avoid the 90-day rule or trying to extend the time period. So you can't have a 60-day or a 6-month orientation period because you're just trying to keep pushing out that 90-day rule. So it has to be reasonable, it has to be bona fide, but as Ryan and I were talking about before the call, who knows really what that means, if it's reasonable. They haven't clarified what that is, other than the rule of thumb is that it has to be a month minus a day. Right, Ryan?
Right. That's one of the things that I was confused about just reading the preamble to the orientation period is theoretically they say this is the time where the employer learns if they like the employee and the employee learns if they like the job, but I don't really know what that means in practice.
Exactly. So here's an example. Susie is hired into a full-time eligible position on June 4th. The last day of her orientation period is July 3rd. That's simple enough. However, it's not simple. Again, the devil's in the details. This is simple for orientation period, but as we'll talk about in the next number 3 where we are, it doesn't jive with 4980H. 4980H is the part of the law that includes penalty A and penalty B. And this is where Ryan did a lot of his technical writing on this topic. But the basic dilemma, and Ryan, I'll let you dive into this after I give a broad overview, but the basic dilemma is you could comply with the 90-day rule and still face a 4980H penalty. And Ryan, you want to talk a little bit about why that could be?
Sure. So if you think about it this way, the 90-day rule plus the 30-day orientation period could theoretically sum up to, or does sum up to 120 days. And if you're talking about a full-time employee under the ACA, so an employee that's clearly going to work more than 30 hours a week, they need to be offered coverage by the first day of the 4th calendar month after the employee's start date, which can be less than 120 days, depending on what day of the month they start on.
And don't panic, because we're going to show you an example of what this looks like, but we want to give you an idea of how screwy this really is, that you might, you know, logically we would think, okay, I've complied with the 90-day rule, I'm you know, home free on penalty A and penalty B, but as Ryan just pointed out, that's not the case.
Right, and a lot of the insurers that we've seen some insurance products that kind of take this completely out of the realm of possibility by only offering a 60-day waiting period time. And then in that case, you're always going to be complying with 4980H. So a lot of insurers that we've seen are just not even confronting the issue to its extremes.
Right. And sometimes that's safer, and Ryan's going to talk about that in a minute, about all the ways that the other pitfalls, if you will, that this provision brings up. Now, we'll cut to the chase because we want to get you on your way, but the quickest way to avoid the penalties is to offer coverage no later than the first day of the fourth full calendar month of employment. And I'll show you an example to tell you exactly what I'm talking about and exactly why this could be confusing. So in order to avoid penalty A, Sam is hired as a full-time employee on January 15th. Sam must be offered coverage by May 1st. Now the reason that that's confusing is because if you were to add 90 days plus a 30-day orientation period, the time would actually be May 15th. But if you waited till May 15th, you now have violated 4980H, and you've now triggered the penalty A for every single one of your full-time employees, assuming that you also didn't satisfy the 70% rule, which is it goes to show you have to know so many things in order to understand this one simple rule. But as a quick rule of thumb, if you just make sure that people are offered coverage by the first day of the fourth month and don't go into the 90 plus 30, that's an absolutely wrong way of thinking, then you're going to be okay as far as 4980H. Ryan, anything to add on that one?
No, I think that's a concise, accurate way to sum it up.
Yeah. We always promise you not to give you way more detail than you want. If there's lawyers on the phone, I'm sure you guys want to talk more in the detail, and Ryan has spent an hour on the phone with different lawyers and even some folks at the IRS grappling over this very confusing statute. So if you do want to talk more, you can contact me or Ryan directly, and we can talk some more about it. But for the employer's sake, offer insurance on the first day of the fourth month, and you're going to be okay. So now, Ryan, this is where Ryan can really get carried away, because one of the biggest pitfalls here is the 95% rule. And it's obviously 70% is the transitional relief. Ryan, without going into too much depth and confusion into how this is, I would like you to give an overall understanding of this 95% connection and why it's something that employers really need to watch out for, because it's a major pitfall. And I'm going to put you on that slide.
Right. So just to describe the 95% rule, in case you're not aware of it, is if you cover 95% of your full-time employees, you're deemed to have covered all of your employees for the purposes of the Affordable Care Act. So you will, in other words, avoid the 4980HA penalty if you, for some reason, make a mistake in offering coverage to someone that you should have been offering coverage to. So it's a really useful tool, and it provides sort of a buffer for mistakes that you're inevitably going to make over the years when trying to comply with the Affordable Care Act. And what I wrote about was how the limited non-assessment periods, and these are periods of time where employees don't count for purposes of the penalties under 4980H, so long as certain conditions are met, how those rules don't work at all with the 90-day waiting period. And to keep it as simple as possible, being otherwise eligible to enroll under the terms of a group health plan are used in 5 of the 6 limited non-assessment periods as conditions for using them. And when you look at the 4980H regs don't define that term at all. And then you look at the 90-day waiting period rules, they do define the term. In the way they define the term, just where some of the conditions are placed in the rules, it's essentially impossible for the rules to work together. So I wrote an article that got well read and reached out to the IRS about this. And the guy I talked to at the IRS was a pretty high-ranking official, and he said that they were not aware of this and it was not intended to be like this. And I told him that wasn't really reassuring for me to tell my clients that, because the way the rule reads, it still doesn't work. So hopefully that they'll put something more official out and correct it in the future.
And the takeaway for business owners, why this is a big pitfall, is because if you don't understand this 95% rule and how it relates to the limited non-assessment period and the 90-day waiting period, the penalties will always be triggered ex post facto or in arrears. So you're going to think that you were in compliance, and you're not going to find out till it's too late that the penalty was triggered. And as you all know that I've been preaching since we started this, the penalty A gets triggered for every full-time employee. So it's not something that you should take lightly. This is something that's a really critical thing. So if you would like more information about that, it's really too in-depth to go into detail on the webinar, but please feel free to contact me or Ryan, and we can help assist you with that. And then also, yeah, please.
I was just going to give the name of the article because it is kind of hidden. It's my publication called The 95% Rule, The Critical Details You Are Missing.
And that's available at Ryan's website at healthcareattorneys.com. Is that what it is, Ryan?
Healthcare-attorneys.com.
There you go. Thank you. And always my number 5, I go back to document, document, document. This is a perfect example of a situation where some of you guys are going to get this wrong because it's confusing. Even the IRS has said that they didn't mean to make it so confusing and make it not workable, but they did. So what is your bottom line? First of all, your bottom line is offer insurance on the first day of the 4th month. That's your first takeaway. Your second takeaway is document. Document to establish that you made a good faith effort to comply. Document to show proof that you sought professional advice. Get a memo either written by your attorney or whoever your consultant is of why you did the strategy that you did, and summarize your strategic plan and your methodology. Make sure that your orientation period is clearly spelled out in your handbooks. Again, this is not conclusive. It might not get you out of the penalties, but it will definitely help at a time when everyone's so confused about it, showing that you made a good faith effort to comply, and did the best that you could is going to go a long way these next couple of years. But this isn't, it wouldn't be your get out of jail free card. We think that this law is going to have to be financed some way, and unfortunately the big part of the financing is going to come from employer penalties. So it's just absolutely critical that you are planning, that you have your plan in place, that you have your plan document done, and if there's anything that we can definitely help. We're helping employers all the time with their look back and measurement method and plan documents, and feel free to reach out to us if there's anything. We've gotten a lot of calls from brokers in the last couple of weeks. We can definitely work with brokers too. And with that we wanted this one to be brief because one of the feedbacks that we got was that we wanted these to be more focused and shorter so that it doesn't disrupt so much of your day. So that's what we're going to be doing going forward. So join us, make sure to join us next week, and the topic will be emailed to you tomorrow. And Ryan, thanks so much for joining me again on this week's webinar. Do you have anything to add about anything that I talked about before we cut it off?
No, I think your documentation point cannot be stressed enough.
Exactly. Like we said, it's not conclusive, but it's really going to go a long way. So thank you again to our sponsor, FreedomCare Benefits. It's a completely 100% compliant solution for employers, and it also it's a self-insured program that has a lot of tax efficiencies. We talked about self-insurance and alternative risk financing over the last 2 weeks. So if you would like to access those webinars, you can do so on our website, yourobamacareadvisors.com. And again, this is never legal advice, so we do recommend that you do talk to your own legal team to make sure that you're in compliance. So with that, thank you so much for joining us, and we will see you next week.